You may remain seated for the moment. Thank you. On the 23rd of May, the two of you pleaded guilty to the murder of Kelyan Bokassa. You have also each pleaded guilty to having a knife in your possession. On the 7th of January this year, Kelyan boarded a number 472 bus in Woolwich. He'd been at school that morning before returning home at about midday. Just after 2 p.m, he boarded the bus at North Greenwich Station. He was due to attend an appointment at the Youth Justice Centre in Woolwich. Once on the bus, Kelyan went upstairs and took a seat at the back on the upper deck. 20 minutes later, you both boarded that same bus. The CCTV from the bus shows that you were both armed with long machetes secreted about your clothing. Once on the bus, you go straight upstairs and approach Kelyan. The three of you recognise each other. You two take out your machetes and immediately began to attack Kelyan by stabbing him. The CCTV shows clearly that you were smiling as you did so. There are 27 stabbing motions towards his body. A, you make 15 stabbing actions, and B, you make 12. Audio from the CCTV reveals the screams from members of the public witnessing this attack. Kelyan attempted to defend himself by using his bag. After the attack, you both go down to the lower deck before leaving the bus at the Woolwich Ferry bus stop. Passing police officers were flagged down and made valiant attempts to save Kelyan's life. A HEMS team and paramedics then arrived and did the same. But despite all of those efforts, at 3:23 p.m. that day, Kelyan's life was pronounced extinct. Police were to find a small kitchen knife on Kelyan in his waistband. As the CCTV coverage shows, he did not have the time to produce it at any stage during your attack. The post-mortem examination showed the fatal wound to be one to the middle of the right thigh that severed his femoral artery. There were 8 stab wounds in total to his chest, left arm and thighs. Examination of the clothing and the bag revealed areas of cut damage consistent with the blows that could be seen on the CCTV footage and Kelyan's efforts to defend himself. Once you left the bus, you ran to the west in the direction of the river. B, you can be seen to discard something into the river, and a later search of the riverbank revealed a machete. A, you phone your mother, who arranged for a taxi to come and collect the two of you. The taxi drops you off in the Glendon estate in Plumstead. 3 Snapchat videos created between 1728 and 1806 that day. You appear in those videos. In them you can be seen making various hand gestures, dancing and smoking. You were arrested on the 15th of January. When interviewed, A, you made no comment, responses to all the questions you were asked. B, you took a similar approach, save that you added that you were not involved. Turning to the victim impact. For any parent to lose a child is a tragedy. The circumstances of this case are particularly so. No sentence of a court can ever truly reflect the loss of a young life. Kelyan's mother, Marie, read her own statement as part of this sentencing hearing. She spoke in the most moving terms of the loss, the death of her dear son, a life gone in just seconds. She spoke about the dreams and ambitions he had, the obvious love he had for drawing, food, his mother and his family. She spoke about the loss she and close friends have suffered, the shock of what happened and the pain that she will face in the days and the years ahead. She poses the question that many listening to this will be asking. How can children behave like this, so completely violent and angry? What have the children been exposed to show such behaviour as this? At the end of her statement, she expresses the hope that the two of you will get the help you need before you are released, so that no other mother has to stand in this court where she did to face the two of you again. The statement of Hashim, Kelyan's father, was read to the court. He expresses many similar thoughts to those of his wife. He too asks why his son's life was taken. What reason could there be, and why words could not sort any issues rather than violence. Many of us can only imagine the impact of grief on Kelyan's mother, father, friends and family. Sitting here as a judge, it is sadly an all too frequent senseless loss of yet another young life to the horrors of knife crime. Turning to previous convictions. A, you are 16 years old. Your date of birth, the 24th of December 2008. So you were just 10 days over your 16th birthday at the time of the murder. On the 15th of March 2024, for a robbery in the possession of a knife, a machete on the 4th of February 2024, so about a year before this murder, you were made the subject of a referral order for 12 months. Whilst on bail for that matter, on the 25th of February 2024, you were again found to be in possession of a knife, that time a lock knife. That matter was dealt with at the same time as the first. I note that at the time of this murder, you were on bail for a drugs offence and under investigation in respect of other robberies. B, you were born on the 1st of April 2009. You are now also aged 16 and were 15 as at the date of the murder. There are 2 previous convictions recorded against you. On the 25th of August 2023, for an offence of having a knife, a zombie knife, in a public place on the 20th of July 2023, you were made the subject of a referral order for 6 months. That offence was committed whilst you were on bail for another matter. On the 12th of December 2023, you were in possession of cannabis. After a plea of guilty, you were made the subject of an absolute discharge. And again, at the time of this murder, you were under investigation for other matters. Turning next to the sentencing provisions. For murder, the only sentence must be a life sentence, and where, as here, those sentenced are aged 18 or under at the date of the offence, the sentence is expressed as detention during His Majesty's pleasure. I must set the minimum term you will serve before you can first be considered for release. I make plain that I am not ordering that you are to be released at the end of the minimum term. Whether you will be released or not at that stage will be a matter for the parole board to consider. Only when the minimum term has been served can the parole board decide whether it is safe to release you or not. If the board does release you, then you remain on licence and liable to recall for the rest of your lives. Schedule 21 to the Sentencing Act 2020 has been amended by Parliament, and most significantly in this case by the provisions of the Police, Crime, Sentencing and Courts Act 2022, and I need to consider where this case falls within that schedule as amended. The start point for sentence in a case such as this for those aged 18 and above would be one of 25 years on the basis of taking a knife to the scene, intending to commit any offence, or have it available as a weapon and using the knife in committing the murder. For those aged 15 or 16, the start point is now one of 17 years. I note that in both pre-sentence reports, the authors wrongly state the start point is one of 12 years. In terms of aggravating features, in my judgment, when one looks at the CCTV, this was a murder with significant planning and clear premeditation. Second, the victim was particularly vulnerable because of his age, 14 at the time of his death. Third, while the use of weapons to commit the killing is accounted for on the starting point, the weapons used in this case were particularly dangerous, being large machetes. Fourthly, there is the use of sustained and excessive force towards the victim. 27 blows were aimed towards him. Fifthly, you both have previous convictions for possessing a knife. Sixthly, in your case, A, the offences were committed in breach of a referral order that you were subject to. Seventhly, the offence was committed by a group. The deceased was outnumbered 2 to 1. Eighthly, the offence was committed in public before members of the public. Finally, the disposal of evidence. B, you attempted to discard your knife in the Thames, and A, the weapon you used has not been recovered. In terms of mitigating factors, whilst age determines the start point, I need to consider the level of maturity. In this case, it is very clear that your intentions were to kill, and so no reduction will be made to reflect any lesser intent. You pleaded guilty and credit will be given for those pleas. The level of credit cannot exceed 1/6 of the appropriate minimum term. There are lengthy pre-sentence reports. In your case, A, the report speaks of your exposure to gang culture and to cannabis. I note that in February 2024, a national referral mechanism was completed and that a conclusive grounds decision made in May 2024 accepting you to be a victim of modern slavery. You were identified as a victim of child criminal exploitation within forced criminality. The report states this: child criminal exploitation is a complex form of abuse driven by a mix of individual vulnerabilities and environmental factors. The author of the pre-sentence report assesses that family experiences, school exclusion, and substance use were all factors that contributed to your subsequent exploitation. The author adds this: furthermore, gangs often mimic family structures, offering protection, belonging, and identity. For you, the sense of belonging was a key feature assessed in relation to his predisposition to negative peer association. The report concludes by acknowledging the offence is of the utmost seriousness and suggesting that your age, developmental maturity, history of trauma and exploitation must be weighted carefully. A is a child of first-generation migrant parents who were largely disconnected from the system by virtue of their initial legal status and continued inability to speak English. This impacted the way in which A was parented and how they understood the local pressures that they were a daily reality for A. In addition to this, A has been an exploited child for a number of years prior to his appearance before the court today. It is hoped that with time, A can receive and respond to rehabilitative and restorative intervention. In your case, B, I note what is set out in the report as to your involvement with drugs, drug dealing, and the Woolwich Dockyard gang. The report details concerns about your involvement with gang culture going back to 2021. The author sets out concerns on events going back to that period, and I quote, "In November of that year, he was located by police in Bedfordshire, an area where he has no known links, kin or otherwise, travelling without a valid train ticket. While being escorted by officers, he absconded from the police vehicle, leading to further suspicion around him being a criminally exploited child. In March 2024, B was again found in the Bedfordshire area, this time in possession of a large sum of cash and 4 burner phones, consistent with behaviour linked to County Lines activity. Between April and August 2023, B came to the attention of the police on 4 occasions. In all instances, B was found with drugs and large sums of money on his person, further exacerbating concerns around illegitimate activity and exploitation. From a developmental perspective, B's early and sustained exposure to exploitation likely disrupted normative psychosocial development, particularly in areas related to identity formation, impulse control, and moral reasoning." At paragraph 2.9, I note that in July 2022, the author says that following an arrest for an incident whereby you threatened your family with a knife within the home, a national referral mechanism referral was submitted. The author states this: "At the time of preparing this report, we've had confirmation of a conclusive grounds decision supporting concerns around B being the victim of child criminal exploitation. The grooming process used in that typically involved a combination of psychological manipulation, inducement through material gain, and threats of violence. B's offending behaviour reflects patterns observed in victims of CCE, such as limited agency, blurred boundaries between victimhood and culpability, and actions taken under duress or perceived obligation." And again, in your case, in terms of maturity, I note what is set out at paragraph 3.10 as to age and developmental stage you're at. The author's view is this: B does present emotionally immature and impulsive due to underlying neurodevelopmental needs, the extent of which have been referenced in the psychological report cited throughout the young person's assessment section. The concerns in relation to his early lived experiences, alongside negative peer influences and the trauma that B has been exposed to, cannot be discounted from the contextual narrative. B's withdrawn stance and emotional numbing in both the commissioning and recollection of this offence is indicative of adaptations to chronic stress, coercive relationships, and emotional neglect. In the conclusion to the report, the author states in similar terms to the report on A that you are a child to first-generation immigrant parents who would have grappled with all the struggle and hardship that comes with a family relocating to a new land with a system that would have been foreign to them at the time. The impact of disrupted employment opportunity and subsequent effect on the family's financial stability would have also contributed to B's vulnerability. Groomed and exploited by gangs from the age of 12, during the most vulnerable developmental years, with older peers exerting significant influence and persuasion over him, has played a critical role in his involvement in serious criminal activity. Additionally, B presents with undiagnosed neurodevelopmental needs, which have likely impacted his ability to fully understand and navigate situations, limiting his capacity to make safer choices. B's background is marked by significant trauma stemming from adverse early childhood experiences. These unresolved issues have profoundly affected his emotional development and coping mechanisms, further compounding his vulnerability to negative influences and harmful behaviours. Turning to mitigation, A, on your behalf, Mr. Rutherford realistically sets out the position that you are in. He refers to the matters in the PSR, some of which I have now read through, and the character letters that I have read. He refers also to the poignant nature of the victim impact statements and the comments made as to violent youth crime. He says that the references that I have seen reflect a different boy to the one that we see on the CCTV. He says that the plea you have made of guilty to murder gives some hope of a more positive future ahead. B, in your case, as I observed to Mr. Langley, some of the material provided in your case does not reflect the reality of the situation. In your case, I have read the letter you have written and that of your brother. Mr. Langley primarily focuses on the level of your maturity and invites this court to make a significant allowance for it. He submits that being in custody has meant you being locked up for many hours each day, but despite that, as the pre-sentence report shows, you've sought opportunities for education and for training. Finally, he submits that early guilty pleas in cases such as this are rare, but it should be seen here as a marker of regret and remorse. Would you stand, please? As I have already stated, there will be life sentences in each of your cases. Taking as the appropriate start point for the minimum term 17 years, then balancing the very serious and significant aggravating factors identified and making some allowance for maturity, leads to an initial uplift to 22 years, and then a reduction down to 19 years, then allowing credit for plea, a minimum term of 15 years, 10 months. That may also be expressed as 15 years, 300 days. The days on remand number 190, and those days will therefore be deducted from the minimum term. In each of your cases, the sentence will be one of detention during His Majesty's pleasure, with a minimum term of 15 years, 110 days. What that means is that before you will first be considered for parole, there will be a period of 15 years and 110 days. If the information which I've been provided with as the days on remand proves to be inaccurate, then the prosecution or defence must notify the court so the case can be relisted to correct the calculation as soon as possible, and in any event within 56 days. When it comes to that minimum term that you will serve, I make plain that I am not ordering that you will be released at the end of it. Whether you will be released or not at that stage will be a matter for the parole board to consider. Only when the minimum term has been served can the parole board decide whether it is safe to release you or not. If the board does release you, you remain on licence and liable to recall for the rest of your lives. On counts 2 and 3, there will be concurrent determinate sentences. As there are previous convictions for similar offences, in my view there must be a minimum sentence. Here the appropriate sentences are concurrent sentences on both those counts of 12 months detention. I ordered the forfeiture and destruction of the machete that was recovered. and if the statutory surcharge applies, then the appropriate order can be drawn up. You may go down.